or it's a Monday. Am I still here?
Yes, we can hear you.
Yes, sir.
All right, 100%. Apologies if my accent sounds like from England. I'm busy self-medicating here. Flu has me on lockdown, but by his stripes we are healed. Amen. All right. I'm quickly going to share my screen again. Then we go through the LMS. I'm hoping that you'll be able to share with those that were or those that did not manage to come in today. All right. All right. So this is the BeMore Institute landing page, right? So I think right now we are familiar with this. From the landing page, we go to login. All right, then you'll put your username there and your password. Then when you log in, you'll see first the screen, right? Then at the bottom right here, you should see a calendar, June 2021. This is this month. Has any of you, when you log in, have you seen this calendar before at the bottom?
Yes, Gabello, I've just visited the site and I've seen it.
All right. So what we did over the period of last week, Rina uploaded all the activities. So what you see here in blue, it will be ASS, then it will write a full name. So if you want to blow this up, you'll blow this up there, then you'll see that it's an assignment for real estate platform, assignment real estate platform, assignment real estate legislation. See, so those are it shows you that there's an assignment due on the 18th, assignment due on the 25th, assignment due on the 2nd of June. Let me go to July quickly. Assignment due on the 2nd of July, assignment due on the 9th of July, 16th of July, and 23rd of July. See, so on the calendar, you will see all the due dates of the assignments, right? The due dates of the assignments will be as per module, and we only have 3 modules: real estate platform, real estate legislation, and real estate practice, right? Let me go back to June. So here it says there's an assignment that was due on the 18th for real estate platform. Yes, sir.
There's a hand by Ludwe. I don't know if.
All right. Yes, sir. Sorry, I can't see when I'm all full screen mode.
Hi, Kabi. I just wanted to find out, am I the only one who cannot see your screen?
Or maybe let's find out from the team.
No, we can see your screen.
No, we see your screen.
Ludwig, you might be using a cell phone or the network might be a bit slow.
It's a cell phone.
Yeah,
Okay.
cell phones. I don't know why Teams struggles with projecting screens on cell phones.
Normally I do see them, but today I don't know.
Yeah, I think your network might be a bit slow.
Yes, okay, that's fine. Thank you.
All right. So on June 2021, there was an assignment due on the 18th. When you click on the 18th here, it will show you that specific day, right? Then it says assignment, the real estate platform activity 1 to 10. You see, so it tells you from which activity to which activity is due on that day. Let's go to the one due this week. When you click the 25th, it says real estate platform activity 11 to activity 30. If you remember, by the week of the 6th of June already, we were on activity 40, you know? So this is just catch up. By now, we should be done by activity 40. Then if you click the 2nd of June, it starts with real estate legislation. It says activity 76 to 87. So the calendar just tells you what's missing. Now I'm going to show you where to find these activities. Before I go there, are we fine with navigating the calendar?
Yes.
Yes, we're happy, thank you.
All right, so to go back, you'll click that double arrow there. It will minimize the calendar.
There's a hand from Maxwell.
Let's say we were on the...
What's tall?
Yes, sir.
There's a hand from Maxwell.
Hi, Maxwell.
Kabelo, how are you?
Good, and how are you, sir?
Sharp, man. I've got a load shedding. I just joined now. You were talking about navigating on the calendar, so I just joined now. Can please maybe show me?
Right.
Yeah.
That's fine. Can you see my screen?
Yeah, I can.
Yes. You see on the calendar here at the bottom. Let me blow this calendar up so that it can be clear. You blow it up like that. It will show you the due dates of your assignments.
Okay.
So it says there was an assignment due on the 18th. Another one is due this week. Another one the following week. Another one like that. Okay. Let's go back to this week. Then there's an assignment due on the 25th. You will click on that number 25 there. Then it will tell you exactly which activity is due. Then it says activity 11 to 30 is due on Friday the 25th. It's under the real estate platform. Then after you see which activity is due, then you have to go to my assignments to get the write-up of that activity. Then you'll go to my modules. Let's focus on real estate platform for now. Then you'll have a real estate platform. When you blow up real estate platform, you should see my study material, my assignments, and the rest.
Yeah.
When you click my assignments, you see, there it will tell you the name of the assignment and the due date. If you check, there was an assignment that was due last week on the 18th, you remember, on the calendar.
Yeah.
Then there was another one that was due this week on the calendar. Then you click file. See the there's someone's mic. She's active. If you can just kindly turn it down a bit. Then the one due on the 25th, you click view file. So with this, the file will be downloaded either to your downloads or somewhere in your laptop. So you have to go and retrieve it there. Then it's still downloading. Let me just reshare my whole screen because now I was sharing just the website. Let me share the whole screen. All right. Can you still see the LMS page?
Yes. And then after that, I noticed all the downloads are on PDF.
Yes, they are on PDF.
And then if you have to submit, then do you have to print and scan or?
I'll show you. I'll show you the submission. Let's go through this first. I'll show you after here.
Okay.
All right. Then you'll go to wherever your assignments are downloaded. On my PC, it goes to my downloads. Can you see my downloads? There's a lot of PDFs. Can you see that?
You can see that.
All
yes,
right.
yes.
Then this is the assignment that I just downloaded now. It's 723. Then you click that assignment that was just downloaded. All right. Then you see there, this is activity 11 to activity 30. Can you see the PDF? Is the PDF visible?
We can see it.
Yeah.
Yes. So this is the write-up of the activity. This is activity 11, 12, 13, up until activity 30 under the real estate platform. Okay?
Okay.
All right. So my advice is these activities, you have to do them in tandem with the presentation. So if the activity is under real estate platform, you have to open
Sorry,
your real estate. Yes, sir.
Maxwell just mute.
Sorry, please repeat that.
No, he has muted. I wanted Maxwell to mute.
All right. These activities, do them in tandem with the notes. Take your notes, put them on the side, take the activity. Each and every activity, it's slotted under its specific module. So these are activities under real estate platform. When you need activities under real estate legislation, you go to real estate legislation, then my assignments. Then under real estate legislation, here are your assignments. You click the relevant one, then you do that relevant one. So that's how you get your activities. But please note, these activities are in the PowerPoint presentation. It's just that in the PowerPoint presentations, it's notes, then activity, notes, activity, notes, activity. But they follow the same numbering. Activity 93 here will be activity 93 in the PowerPoint presentations. Any question before I move to how to upload activities? Are we fine? Are we good?
We are fine. You can go on, Cabello.
All right. Let me go back to home. So under home on the calendar, we see there's an activity due on the 18th. Under real estate platform, we go to my modules. Then you look for real estate platform. Then my assignments. All right. So now when you downloaded the activity, you said view file. Then you download. When you say select assignment, then it gives you now options. It says, what's the name of the assignment? This is the due date. Then there's a tab for upload assignment, right? Then you click browse. So colleagues, with regards to this, it says activity 1. Let me just cancel here. It says activity 1 to activity 10, right? Please make sure that when you submit as well, consolidate your activities from 1 to 10, put them in one document so that when you browse and upload, you are uploading activity 1 to 10 so that it's easy for us to match the assignments 1:1. So meaning today don't load 1, tomorrow 2, tomorrow 3. No, you do 1 to 10 block, put them under one document, upload activity 1 to 10. Then from our end, when we download, we can download per student. We'll know exactly which student uploaded, which one didn't. Then remember, for the group assignments, you'll have to write the names of all your group members, but each and every person has to submit. So I can't say, I'm in a group with Munasi, Munasi will submit on our behalf. Munasi has to submit the same work, and I also have to submit the very same work. Is that okay?
Yes, it's clear.
All right. Then there you see the activity, you see when it's due, then you browse, then where you saved your activity, right? Then you'll go there and click that activity. Then after clicking that activity, you say open. When you say open, you will see the name of that document that you clicked. Yours will be written activity 1 to 10. Then you say upload file. All right, let me go for the 15th, sorry. For the 25th. Browse. Then you see it says file uploaded successfully. You should see this in blue. If you don't see this in blue, it means it was not successful. Then you click, after it says upload, file uploaded successfully, then you click submit. Then it says assignment uploaded successfully. Then it appears here to show you exactly which date and what time you uploaded. You see, so all your uploads per that specific module will be here on the middle right. So all your uploads will be here on the middle right. Is that fine?
Yes.
All right. Let's do another example. Let me go back to home. So from the calendar, we see that real estate legislation is due on the 2nd, activity 76 to 87. Then you'll consolidate those activities. Then under my modules, you'll go to real estate legislation. Under real estate legislation, you go to my assignments. Then you see all the assignments there. Then you choose the one that you want to submit for. You say select file. To download, you say view file. To upload, you say select assignment. Then it shows you there. Then browse. You go to browse. Then you open the one that you want to open. Then you say upload. All right, it says it's not selected. Let me try that again. Then it says file uploaded successfully. If you don't see the file here, it means you didn't submit. Make sure you submit. Once you click submit, you will see the write-up there. File assignment uploaded successfully on this specific day, on this specific time. All of them will be lined up there. Any questions with regards to downloading activities and submission of activities? Let me take hands. Are we good?
We good, Kabelo. Thank you.
Yes, we are
Alright,
good.
awesome. Thank you very much, colleagues. Please do try it out tonight. If you have a challenge, please send your challenge on the group and we'll attend to it. Please note, some people have not tried this and they think on the last minute they'll quickly go to LMS, download and upload, only to find out that when they go there, they'll have problems and the due dates will be so close. Another thing, colleagues, as soon as you upload your activity, please remember you have to submit a physical file. So whatever you submit to us, that must be filed on a hard copy, as in printed. So for now, you can store them electronically, but a time will come when you'll have to submit that hardcore file. So I would advise, as soon as you submit your activities, print them all up, put your signature at the bottom, file under that relevant module so that it does not become a lot of work at the end of the term. All right, Rina Numisa Moses, have I missed anything with regards to activities?
Moses, now, sorry, Kabela. I just want to ask what is going to happen if the activity is bigger than 4,000 megabyte, what we experienced?
Yeah, I think that one, Munasi is still working on that one. So I think for now, since there's not a lot of pictures in the activities, it should not be a challenge. But should a student experience a challenge, they must take a screenshot and send it through to Munasi.
Okay, no, thank you.
Yeah, but I'm hoping that it will not pop up, as majority of the activities it's right up. But yeah, we are working on that.
I think what we did, Kabelo, is we load everything up to last week's class to make sure that, we are on par with everybody.
Yeah.
So I will load everything tomorrow morning from now on.
Yeah.
We will have everything up, but we want everybody to know what to do.
All right. Awesome. Maybe Rina, before you come in, I have an exciting announcement. If you can just allow me to open my WhatsApp quickly. Can you see my WhatsApp?
Yes, I
Is my
can.
screen visible?
Yes, Kabelo.
All right. So colleagues, this week, Wednesday, we have outsourced the expertise of our colleagues from Nedbank, right? They're going to come and just tell us the products they have available at Nedbank, bond origination opportunities and processes, development funding opportunities, and the different qualifying criteria. So please do spare us that 2 hours from 5 up until 7, so that at least we can come and just find out how the banks can assist us in this walk of ours as property practitioners. So please, we are going to send this to the group and the registration link. Please do register for this so that we know who's coming. And also we'll have a section for questions that you might have. So send us the questions up front so that our panel discusses those questions beforehand, but you are more than welcome on the day to ask questions. So please, this week, Thursday, on the 24th of June, from 5 till 7, it will be a similar setting on Teams. We are going to be having experts from Nedbank. We have been engaging them for a while now. Finally, they gave us a date for this week, Thursday. So we apologize for the late invite, but please do come. You are more than welcome to invite anyone. It's a free event, open for everyone. So please do send the word out to your colleagues from other companies and institutions as well. They are more than welcome. The formal invite will be sent to you shortly. Thank you very much, colleagues.
Kabelo, I just want to confirm something. It is for Thursday, because
Thursday.
originally we thought, and we actually tried to get them on Tuesday,
Yes.
but they've said no, Thursday. So
Yeah,
I just
so
want to confirm that.
Yeah, we couldn't get them on our normal class day, so we settled for that Thursday.
Okay, great.
100%.
100%.
All right, colleagues, thank you very much. Rina, over to you, ma'am.
Okay, thank you, Kabelo, and thank you for everyone. And I think this LMS was well needed at this stage. And if there's any more questions, we can set up another meeting to, if anything else, if you experience any other problems, we can set up one more session for this, because we have to get this LMS in a very good working for everyone. Is there anybody else that would like to ask any questions? Any comments? If it's not a question. Okay. Sorry, I hear somewhere. I just want to mention that I'm not in my house, so I don't have two screens. So please, if you want to jump in with a question, I'm not going to feel offended if you just start talking, because I will not be able to see any hands. So please help me with that. I'm going to share my screen. But what I want to ask now, it went through my mind as Kabela was talking and mentioning about Nedbank coming on board on Thursday, is that we do have a class with fires. And there was one of the students that said that why are we doing fires? Because what is our role in fires, as fires is the Banking Act and regarding the bank's input. So I just want to ask, do you think we can swap some of the modules around a little bit from tomorrow night? Maybe tomorrow night, instead of going ahead with where we stopped today, is to do the fires. Fires is, I think, in 2 weeks' time, actually, but because of the fact that the bankers are here on Thursday, maybe you would like to ask them questions out of the Fires Act. Can I just get from the platform, how do you feel about it? Moses?
It's not a problem, Rina, with us. It doesn't matter.
Yeah, we can do the Phase Act.
Yeah, but the reason why FIS is part of real estate is that the line is very, very narrow. We intend, and I think it comes automatically when you take a client out to show a property, is to start talking about the finance and insurance and things like that. So we must know what can we do and what is not permittable. And also, especially now with Poppy coming in, it feels to me Poppy is going into more than one department than only, securing your personal information or a client's personal information. So I think it will be good if we do the fires. I'm going to do it then for tomorrow. So instead of going on where we stopped today. Thank you. Then I'm going to share my screen quickly with you. I think I've done it already. Can you see my screen? The real estate level 4.
Yes, Rena, we can see it.
Okay, thank you. All right, the real estate level 4, Moses spoke last week, and it went also sales and marketing, but there's different areas on the sales and marketing in real estate. And to market a property, this is module 2. What we're going to do now is sales and marketing of real estate. This is the module 2. In module 1, we did and demonstrate the understanding of real estate marketing, outline the product, and discuss the buyer behavior. So that is what I'm not going to read everything. Analyze results and sales of leasing and residential property, determine future sales focusing and opportunities. Number 2 is sell a property, demonstrate understanding of prospecting techniques and methodologies with examples in various real estate contexts. 3 is let and hire a property. So this is the real McCoy, if we can call it this way, of real estate and what we must know. So we're going to start this week by introducing the Sectional Titles Act. I think the Sectional Title Act is the little bit difficult act, and there is quite a lot of rules and regulations in the Sectional Titles Act that you must know and be careful for. Okay, a sectional title lifestyle brings together people from diverse backgrounds, age groups, interests, and philosophies. Often the only common factor is ownership of a unit in the scheme in which they live. The Sectional Titles Act prescribes management and conduct rules that apply to every sectional title scheme and lay down the framework for running such a scheme. The Act allows some rules to be changed, providing none of the changes go against the spirit of the Act. The procedures to effect these changes are prescribed in the Act and must be carefully followed. Now, what I can just mention on the Sectional Titles Act with the rules and regulations is that you must get the rules and regulations from the body corporate. and you have to add it onto your offer to purchase. If you don't do that, there was cases in the court where the purchaser said, but they didn't know about it, and they win the case, and it's terrible problems for us as estate agents, and it is also under the Consumer Protection Act, so we have to do that. So in word, the definitions of the Act: the sectional title developer is the registered owner of the land that lies within the area of a local authority on which a building or buildings have been built or will be built, and which has been divided or will be divided into 2 or more sections under a sectional title scheme. The architect and land surveyor, we all know that the architect is drawing the plans and the land surveyor is picking the outline and the boundaries of the property. A section. Now, what is a section? If you can think of the land, the number of the land will always stay the same. So if it's earth number, say 999, and you are going to build a 30-unit building there with a units, then each unit will have a section. So it will be earth 999 portion 1, and that will be then that specific flat. So you will then have 30 different portions, but for that one specific flat. And then also you get door numbers. Your unit number and your door number is not always the same. It all depends on the developer and on the architect, how they number the units. Undivided share in a common property. Now, this is an interesting thing, and nowadays I see quite a few of the developments are using this thing of an undivided share. An undivided share means that the owners cannot dispose of an undivided share in sectional title independently, as in separate title ownership. Common property relates to the land on which the scheme is built, along with a part of the buildings that does not make up part of any section. I've seen a property development land. I can just mention to you, and that will give you an idea of what does it mean, where the owner did not divide the land into, say, 2 portions, and he is selling off just a portion of the land, but it's not being divided at all. So it's like 6 hectares, but he divided, and he said now he wants to sell 2 hectares. So then it is an undivided share. So it is a total different agreement, sale agreement. It's not one of our standard agreements. And I will always advise, if you get something like that, is rather let an attorney draw that agreement for you and assist you in that matter, because there is a lot that you have to take in consideration on this undivided share. But coming to a sectional title unit, the undivided share is the common area, what we also know of, where you get your swimming pools, your passages, and your garden, and that is your common, we call it common area, but that is also undivided shares. Any questions? In buying into a scheme, owners will acquire a section and a share of the common property. These are collectively known as a unit. In practical terms, a section is usually a flat or townhouse, but may also be a garage, domestic staff room, parking bay, or external room. Just for interest's sake, and to get some answers from the floor, if you buy a sectional title unit, say for instance, let's go back to a flat. What do you actually buy there? Can somebody tell me?
Hello, Rena.
Yes, hello.
Yes, Karen. Yeah.
Hi, thanks, Karen.
Yes, I think you are actually buying the interior. You know, you are buying the interior of the unit. You are not buying anything outside of the unit. You know, whereby you are only allowed to bring about different, or should I say, to bring about changes inside the section. exactly apartment. You can paint inside, but then outside you are not actually allowed to do anything. So I think you are buying the interior.
You're 100% correct there, Karen. We always joke and say, you know, your bricks, normally it's 2 layers of bricks. So you are buying your side of the bricks and up to your roof and your floor. That is only the inside, like you said, the interior, except of your geyser. Your geyser is normally inside the roof. So except of the geyser, you're only buying the interior, unless there is a garage, and then the garage must be specified on your contract. If there is a domestic staff room, it must be specified. And also your parking bays and any external storeroom. So whatever else you're buying must be specified on your contract. Otherwise, it is the pool, it's a common area, and you have the usage of it. These townhouses with the little gardens at the bottom, although you pay more for that, normally than the top units, you only got the usage right on that, and sometimes they say you've got exclusive usage right on it. Then that means that you can use it, but it's not yours. You cannot claim it actually. The body corporate will come in, normally they will come and cut the grass and keep it clean, but as you said, you are not allowed to do anything outside. If you want to do outside something, like for in case even to put up a dish, you have to ask permission for that, and then they will tell you exactly where can you put the dish up. You can't just carry on and do it wherever you want to put it up. Also, if there's a little balcony, you're not allowed to enclose the balcony, because the balcony is part of the common area actually, for your exclusive usage. And if you close the balcony, you actually increase the size of your unit, and that's not permittable. If they will allow you to do so, you will see that they will allow everybody to do so, but then you have to pay in an extra amount of money because your unit is getting bigger now. Any questions? Please, we have to talk this thing through. It's also the Sectional Title Act is very important.
Hello, Rena.
Hello, Karen.
Yes, I have a question with me. We've just agreed that you are actually buying, you know, the area of the unit. So my question here is, what if a window happens to break, you know, due to
no, the window is yours. The toilet, the plumbing is yours, as if it's your house. It's only the outside window frame that you're not allowed to paint.
Oh, okay.
But when it breaks, yes, you have to paint it obviously the same color. You can't go and, if it's a beige, go and do it blue now.
Oh, okay.
So you must stick to the, you know, the how it looks like. That's the thing. You can also not just put awnings up or things like that. You have to ask permission for that. But it's a good answer, a question. Any more questions?
Hi, Rina.
Hello, yes.
So if sectional title, I'm only buying half the brick inside, right? Then outside it's the body corporate. Why is it that these lights that are considered common property, let's say you see the one right above my door, that light, it's outside, right? Why is it my responsibility to fix it when it blows up?
Is it in your contract? Do you know that if it's in your contract?
Hello?
Hello, Cabello, is it in your contract? Okay. Can you hear me?
Come again?
Is it in your contract that you must fix it?
Sorry, Rina, my network is quite bad.
So is it in your contract that you must fix it?
Unfortunately, I did not read the contract.
Okay, you must read your contract, please, because if it's specified in your contract, then unfortunately they, you know, your lights and light fittings inside is normally your baby and responsibility. But is that light on top, on a balcony or on a stoep close to your property, or is it on a passage? Cabello, can you hear me?
It's yeah, I can hear you. It's on a passage, but
If it's,
the passage is in front of my door.
yeah, but if it's on a passage is common area, then it means it's actually the body corporate that must come and fix it. They can't expect from you to fix it. If it's on a balcony or a stoop or something like that, that you've got the right to use a usage right, then you will have to fix it.
Thank you.
Any more questions? We learn actually a lot out of questions because it's very good questions that's coming out. Okay, the outside of the building is owned by the body corporate. In the interest of keeping uniformity, therefore, minor changes may be approved in writing by the trustees. This includes all external changes like aerials, like I said, satellite dishes, awnings, enclosures, changing of exterior color schemes. The changing of exterior color schemes, they are not very fond of approving that. The role players involved in a sectional title scheme are the developer along with his or her appointed architect and or land surveyor who must draw up the draft sectional title plan for the development. This draft plan gets submitted to the Surveyor General in Pretoria for approval. Once the draft has been approved, the developer may apply to the Register of Deeds to have the sectional title register opened and to have the sectional plan registered. The units can then be transferred into individual owners who make up the body corporate of the scheme. Property that is divided into sections and common property makes it possible for a person to own a unit in that property. This is the prime purpose of Sectional Titles Act. Before the Act came into operation, it was impossible to buy a portion of a building as a portion could only be rented on a temporary basis. This was due to the common law principle that all permanent attachment on land form a single legal object with the land which is inseparable. This means that the owner of the land was also automatically the owner of the buildings on the separate title land. Sole ownership of a separate title property includes the land and all permanent improvements. The land is described on the title deed of the property along with any restrictive conditions that have been registered against the title deed and any other limited real rights that burden the property like servitudes, mortgages, and long-term leases. The Sectional Titles Act overcomes the state of affairs whereby a purchaser of a unit which comprises one or more sections coupled with an undivided share in the common property, now on transfer becomes the sole owner of the section as well as joint owner of the common property. It is of particular importance that an estate agent who is party to the selling or leasing of a sectional title units understand the nature of sectional title ownership, and the following aspects need to be taken into account. When the offer to purchase or lease is drawn up, the sectional title unit must be accurately described as the object that is bought and sold, hired and leased. The opening of the sectional title registered as a prerequisite for transfer. The opening of the sectional title register as a prerequisite for the payment of monies held on behalf of the developer to the developer. Requirements relating to the sale of a unit of plan. Requirements relating to the sale of a unit in an existing building. Requirements relating to the transfer of a unit. The management rules of the scheme, the prospective owner's rights and duties with respect to code of conduct rules, the prospective owner's rights and duties with respect to participation quotas. So there's a difference of the documentation that you add onto your contract if it's an existing sectional title unit or if it is well, sectional title is not really pre-proclamation, but we can call it in brackets like pre-proclamation because we all understand what that means. It is to sell off plan. That's basically the same thing. But on sectional title, you cannot call it pre-proclamation, but it's a selling off plan. And if you sell off plan onto your offer to purchase, you have to add pictures of where a site development plan, also the unit, what it comprises, what's in the unit, how it's going to be built, what's the fixtures and fittings that you're going to add on. So there's quite a few different documentation that you add onto the sale contract if it's a selling off plan. If it's an existing property, you have to put the code of conduct onto the offer to purchase. And if you do have a site development plan, you can put that on as well and mark exactly where this unit is situated on the development. It also helps for the valuator when he must go out there, not to look where is your property, but he can see where the property is on the site development plan. Any questions to that? Okay, the procedure to open a sectional title register. The procedure that has to be followed in order to open the sectional title register needs to be understood so that the agent can explain the necessary activities to clients. The rights of the developer and the purchaser also need to be understood and explained. These aspects are as follows. After a draft sectional title plan has been approved by the Surveyor General, the developer applies to the Register of Deeds to register the sectional title plan and to open the sectional title register in terms of section 11.1 of the Act. The opening of the register means that the units come into existence and can be transferred to the purchasers. The application must be done in terms of the prescribed documents, which include a sectional title that has been certified by a conveyancer, whereby any servitudes and conditions of title that may exist on the land, as well as other conditions which may be imposed by the developer, are documented in the event that the developer has registered a mortgage bond over the property. The mortgagee consent must be obtained. I just want to stop here for 1 second. I want to try our students here. Tell me, why will you say that if you sell a new development, sectional title or full title, but we talk sectional title now, that the purchaser does not pay the transfer cost? This is just an interesting question that came up here.
Hi, Rina.
Yes.
You know, I think the principal reason might be that the property is not actually transferred from the names of the former owner into the names of the new owner. I think maybe the property has not yet been registered at the deeds office. Let me put it like that.
Yes, you are 50% there. It's a good answer, 50%. Anybody else that would like to add on this?
Hi, Rina.
Yes.
I think if the seller is registered on the tax and the vendor, then the buyer doesn't have to pay the tax.
Not really that if it's an existing property, yes, but not yet. Let me quickly tell you, is there anybody too or anybody of your group there that would like a short, doesn't matter if it's wrong. This is just an interesting fact.
Okay.
Anybody else that wants to try?
Can I try for the last time, Rina?
Yes, you can. Yes.
You know, maybe the reason is that the property, you know, is being bought directly from the company, or should I say, it is not bought from an individual. The seller is not an individual, but it's a company.
No. Then let me help you then. And this is just something that came through with this. Remember, each property must have a title deed. Okay? If you start a new development, there's no title deeds. So part of the attorney's job, if I can call it a job, is to draw up the title deeds for each unit. That forms part. They open the sectional title plan and they open the sectional title register. And with this register, each unit must have a title deed. So the developer pays for that, for the attorneys, to draw up all to register, but it's part of the process there is to draw up the title deeds. So he's getting paid in any way by the developer. And part of your development cost is attorney's fees. So it's in there, and that is why we sell off plan without transfer cost, because the developer already paid the transfer. It's actually, if you can work it out that way, it's included in your purchase price already. Does it make sense?
Yes, it does. It does.
So normally the purchaser will only pay for the bond cost, because some clients will maybe buy cash, other will take 100% bond. So the developer cannot stand in for that. And I think by law, in any case, is it illegal that the seller, whoever the seller is, will pay the bond cost, but you can include the transfer cost there. So this is just an interesting fact. Why there will be no, you might, when you sell maybe one day off plan, get that on a question to say, why aren't we paying the transfer cost? And that is the reason it's already included in the attorney's fees. The register will register the sectional title plan and give it a specific number once the requirements of the Act have been complied with. Simultaneously with the registration, the register opens the sectional title register for the property and issues the developer with a certificate of registered sectional title for each section, along with its undivided share in the common property. The developer is also issued with a certificate of real right with respect to any exclusive use areas that have been denoted on the sectional title plan. You're all happy with this? At this stage, the property or the land improved has legally been divided into sections and common property in terms of section 13.1 of the Act. The developer is now in a position to grant transfer of ownership in the individual units to individual purchasers, and the estate agent or conveyancer holding monies in trust payable to the developer may now pay such monies over to the developer. I can just mention is that when it happens that they opening the sectional title register and the developer is now, everything has been divided into different units, and the land has been divided, then the sectional title, the common area, if I can say that, once that is being, the whole development is being registered and signed off, then that part will stay in the company, and the company will be a non-profitable company, and then the body corporate will take over, and most of the time they will allow some of the owners to be part of the body corporate and to make decisions on that regard. Any questions? Okay, the rights and duties of the purchaser. The purchaser, once transferred has been effected, must make use of his or her section and or exclusive use area in any way provided he or she does not cause a nuisance to any other occupier of a section in the development scheme. If a particular section or exclusive use area has been earmarked to be used in a particular way in terms of the registered sectional title plan, the purchaser may only use it in the prescribed fashion unless all the other owners in the scheme give their consent for it to be used differently. The construction of an improvement on an exclusive area may not take place without consent from the trustees, which may not be withheld unreasonably. Allow any person authorized in writing by the body corporate to reasonable times to enter his or her section or exclusive use area to inspect, maintain, repair, or renew parts like plumbing, electrical wiring, cables, etc. They maintain his or her section exclusive use area in good repair and in a clean and neat condition. Carry out all work on the section that may be instructed by the local authority and be liable to pay the expenses thereof, and notify the body corporate immediately of any change of ownership in the section. The purchaser, once transferred has been effected, is entitled to subdivide the section or consolidate two or more sections, provided that the trustees of the body corporate have consent, as well as the mortgagee of the section. A plan for subdivision or consolidation must be approved by the Surveyor General, and the plan must be registered at the Deeds Office. Extend the boundaries or floor area of the section. That is what I mentioned about the balconies or the steps. Take out insurance to cover any damage to his or her section, although the body corporate has taken out insurance. So that is the outside normally of the building. Inside, like for instance, you can have insurance there. Say for instance, there's a fire and your cupboards are burned down, that you can at least fix that. But when you take out the insurance, you have to specify it as clear as possible. Make use of the common property, may not appropriate any part of the common property for his or her exclusive use unless such a right has been obtained to this effect. Transfer his or her registered right to the exclusive use of a specific part of the common property to any owner of a section in the particular sectional title development scheme. So you cannot go if there's a garage and sell off your garage to somebody else. That will not be permissible. Enforce his or her rights by normal legal proceedings in a prescribed fashion by serving written notice on the body corporate, in which the body corporate is giving 1 month to institute proceedings, and should it fall to do so, a court application can be made. Any questions? Okay, the process of division into sections and common property. When dealing with the division of a property into sections and common property in terms of the Sectional Titles Act, one needs to distinguish between 3 different scenarios. A unit that is sold off plan, in other words, where the sale are to take place before the sectional title plan has been registered. Or the sale of a unit by a developer in an existing building, and by an owner other than the developer in an existing building. We can call that our second-hand properties. That is basically what it means. Are you fine with this scenarios? Okay, off-plan sales as opposed to sales of existing units by a developer. It is possible for a developer to sell units off plan before the sectional title register has opened. Section 26 of the Alienation of Land Act 68 of 1981, however, states that no person may receive any consideration, including the deposit, when a unit not yet in existence is sold. I can just mention here that if you sell off plan, before you can start selling off plan, you must have the building plans that must be approved. So you must be the building plans with the site development plan, because there's nothing. If you look at the land, it's just vacant land. You don't see any buildings. So you must prove on your map and on your plans exactly where is the specific property that the purchaser will be purchased. So that is why it is very important that you have to have that. And then your bond originator will, prior to you selling off plan, acquires from the builder their NHRBC certificate and quite a few other documentation, including the plans, site development plan. And then you will go to the bank, the financials, and they will apply for what we call a desktop valuation. So based on the list of what is inside the building and the finishes and what will be, how it will look like, and the plans, then the bank will do a desktop valuation. So when you put in an application for a bond, that will also be in the contract, it will say that it is selling off plant, and there will be a clause in there to say that the sectional title register has not been opened yet, to cover yourself up that if that transaction falls through or the development doesn't go ahead, nobody can claim anything from you or say misleading or anything. So it is important that you do get a bond originator on board from before you start selling, and let they do through the banks a desktop valuation, and it makes life just much more easier to get the bonds as well. And yes, the bonds will be approved, but it can only be registered as soon as the building is complete. So either or, if it's one building with 40 units, the builder will have to complete the 40 units first before the sectional title register can be opened and before registration can happen. If it's this 4 unit little flat groups, then that 4 units, each one must be finished. As they finished, then they can register off. So it's more lucrative to do the smaller developments like that, or the smaller building units, because of the fact that payout from the financials can happen sooner. Any questions to this? Okay, the term, sorry, is there somebody that wants to ask something? Okay, the term consideration refers to any portion of the purchase price and interest, excluding rent or occupational interest. In the event that a deposit is payable to an estate agent or conveyancer, the amounts thus paid by the purchaser must be kept in the estate agent's or conveyancer's trust account until the date of registration of the sectional title plan. If the unit in an existing residential building are to be sold and there are tenants occupying the apartment, Section 10 of the Sectional Titles Act prohibits the developer from selling the units unless the following requirements of the section have been complied with. Developer must, in writing, offer the unit for sale to the tenant. And people, this is very important. This is part of your Rental Act and of the Sectional Titles Act. If you take over a building and you're going to sell the units off, you must offer, and this must be in writing, you have to offer the tenant that is staying in that apartment a first right of refusal to say yes, they would like to buy, or no, they don't want to buy. If they say they don't want to buy, by law, you have to give them actually a minimum of 2 months notice, unless the tenant is willing to move out sooner. But it gives you time also to market the property, and you request from the tenant permission to bring people through. This offer must be kept open for 90 days for acceptance by the tenant. And this is very important. So if you ask the tenant, if they want to buy, you must give them 3 months to actually, well, not only to say yes, they're going to buy. During this period, they must also apply for a bond. If the tenant has refused the offer or the 90 days have expired, developer must sell the section in question to another party. The developer may not, for a period of 180 days thereafter, sell the unit to another person at a lower price. And that is important, because you offer this unit to the current tenant for an X amount. then you cannot, after 180 days thereafter, sell the unit to another person for a lower price than that at which it was offered to the tenant, unless the developer first offers it at a lower price to the same tenant for 60 days. Should the tenant now not accept the second offer at the lower price, or if the period of 60 days expires, the developer may sell the unit to another party. Notice to vacate may be given subject to the provisions of the lease. Any contract of sale that the developer enters into that is contrary to the above provisions will be null and void, and any contravention of these regulations is a criminal offence. Any contract of sale that the developer enters into that is contrary to the above provisions will be null and void, and any contravention of these regulations is a criminal offence. Before the transfer of an existing unit can be effected, the Register of Deeds requires an affidavit by the developer declaring that the relevant deed of sale is not contrary to any of these provisions, and in the event that they apply to the particular existing unit. Are you satisfied with that? Any questions? Sectional title sales by persons other than a developer. There are no restrictions in the Act pertaining to sales of an existing unit by an owner who has purchased from the developer or another owner. The only requirement is that the seller must notify the body corporate as soon as the sale has taken place and a new owner is to become a member of the body corporate. It is, however, impossible for the transfer of such a unit to be effected unless the body corporate has issued a clearance certificate to the effect that all amounts due have been paid in full, or that satisfactory provision has been made for the payment thereof. Now, this is if you sell a sectional title unit, apart from the fact that you get clearance certificate from the municipality, you must also get a clearance certificate from the body corporate, and this is exactly what they're talking about, is that they will declare that you don't owe anything. And another interesting fact here is that, you know, sometimes there's a special levy. Maybe it was required to put like an electrical fence up, and that was not part of the deal from day one. So then they will call out a special levy. That levy can be 1 month, 2 months levy, or maybe a year. Depends on what they want to do. That special levy is unfortunately also the same as your municipality rates and taxes. The previous owner will be liable for the levy up to the date of transfer, and from date of transfer, the new purchaser will then be liable for that special levy. So although that special levy was called out during the time that the property was still in the first owner's name, the first owner is not liable for the full special levy up to the time that it expired. Does that make sense? Is it clear? When a sectional title unit is sold, it is imperative to ensure that the agreement of sale is valid in terms of the disclosure that need to be made. The following disclosures must be made in the deed sale. Where the developer or the body corporate has reserved the right to extend the scheme, it must be disclosed in every agreement of sale. If it has not been disclosed, the purchaser may have the agreement declared null and void. If the scheme is not a residential only scheme, the total PQs that have been allocated to the sections and the PQs of the section that is being sold must be disclosed in the agreement of sale. If this has not been done, the agreement can be cancelled by the purchaser due to non-disclosure. If the developer intends varying the values that have been attached by the owner, voting power, and the liability of payment to the body corporate in terms of a monthly levy or to the judgment creditor of the body corporate, the variation must be disclosed in the deed of sale unless the sectional title register has been opened containing the variation. If the disclosure in the deed sale has not taken place, or the register does not reflect the variation, such variation would be invalid and have no force and effect. Disclosures are very important to property buyers. What do you think could happen if you fail to disclose information to any of the parties? I can just add on here, there was a case where the agent did not inform the purchaser of the amount of the levy, and they didn't ask this agent what was the amount of the levy. And at the end of the day, when the property was registered, the purchaser just turned around and there was a court case, and the court rules in favor of the purchaser, and the agent is liable to pay that levy amount every month until the time that the property is sold, or yeah, I don't know, it's infinito, because they did not disclose it. So as part of this, that is one of the reasons why I always suggest is you take that copy of the levies, the body corporate account, and you attach it to your contract and let them sign on it so that they acknowledge that they know about the levy. Normally, our sectional title contracts make provision for a space where you write in what is the amount of the levy. But you know, if I look at COVID now and how long does it take for registrations to go through, my suggestion still stays the same, is that take a copy of that levy statement invoice, attach it to your contract, and make sure it states that your contract say that the purchaser acknowledged that he's purchasing into a sectional title scheme, and there is rules and regulations he must adhere to, and also levy and the body corporate account. So make sure it is definitely in your contracts. Documentation and certification requirements. The developer of a sectional title development scheme must appoint an architect or land surveyor to prepare the draft sectional title plan after inspection of the property has been undertaken and subsequent measurements have been in accordance with the section 6.1 of the Act. The plan must contain specific information as prescribed in terms of section 5.1 of the Act as well. Should the architect or land surveyor find that the building in question does not comply with the local town planning scheme, or that it does not comply with the building regulations, he has to apply to the local authority for condonation of the non-compliance. The accuracy of the draft sectional title plan is regulated in terms of the Act, which requires the architect or land surveyor to diligently comply with the obligations set out in the Act. The activity to this, I'm just going to read it, touch on it. List the documents that have to accomplish the draft sectional title plan to the Surveyor General for approval. Beetle certificates are usually not required where the property is a sectional title unit. In many sectional title properties, the section consists of the inside of the unit up to the middle of the containing walls, floors, and ceilings. Beetles infest the wood in a building, especially the roof trusses. The unit which the owner is responsible for excludes the roof trusses. The body corporate is therefore responsible for the beetle damage. But remember, the owner is a member of the body corporate and is therefore responsible for a portion of the body corporate's expenses. So yes, the body corporate can issue that beetle infest certificate, but he can hold you responsible for a portion of the expenses to getting that. And the Surveyor General will approve the draft sectional title plan if all the necessary documentation has been submitted and he is satisfied that the plan has been drawn up in accordance with the provisions of the Act. Environmental legislation must also be adhered to. Once a draft sectional title plan has been approved by the Surveyor General, the developer may apply for the opening of the sectional title register at the Deeds Office. The conveyancer certificate in terms of any servitudes and conditions of title that may exist over the property, as well as conditions to be imposed by the developer, must accompany the application. The mortgagee Consent must also be obtained in writing and attached to the application. The Register of Deeds will then register the sectional title plan and it will receive an official number, and the developer will also receive a certificate of registered title for each unit, section plus undivided share in the common property. The property is now deemed to be divided into sections and common property and can be transferred to new owners. Your self-assessment, this is quite an interesting one. What is the purpose of the Sectional Titles Act, and what are the differences between ownership of sectional title property and that of other title property? I will definitely come back to this questions, and I will explain in my own draft what the difference are. Any questions up to here? This is now sectional title. So before we move to market a property, any questions? Let's talk about this.
Rina, Venetia has a question. Excuse me.
Thanks, Venetia.
Thank you, also, Miss, and yeah. So Rina, my question is, I don't know, maybe I might have missed it. What's the Sectional Titles Act saying about, let's say if I decide to change the internal structures of my unit, is there any changing from a 2-bedroom maybe to and add an additional room, like in the lounge or something like that?
No, sorry. You cannot change the original plan. The original plan must stay as it is. If you want to change the internal, say for instance, you've got a very big lounge and you want to divide that as long as your floor plan, then you must still ask permission from the body corporate to do so. But you're not allowed to break out any walls or things like that. But you have to ask permission. But normally they prefer it must stay as it is on the plan.
All right, thank you.
Because any changes on the structure, you must remember you have to change the plan of your unit, and that is it's not registered at the deeds office, it's not registered nowhere, so it's going to be a problem. You can, however, paint it. You can paint whatever color you want inside. Inside is yours. Any more questions? Nothing more on sectional title?
So Rina,
Yes.
right on that, on the same similar question, because I've seen many instances where the unit gets changed inside, they actually no longer look the same as the other units. What happens in that case? Because there's
okay.
Yeah.
Moses, it's actually the same as the full title when you build on a garage and you're not supposed, it's not on the plan. You have to change the plan. And before you can change the plan, you have to get permission from the body corporate. I know in some of the flats that I've seen of the old flats was quite big flats. Now they use drywalling.
Yes.
I think from the architect side, they can help us, but with drywalling, you do not need plans. So I don't think they can disqualify or punish you if you use drywalling, as long as the original building walls stay where they are.
Okay, yeah, definitely. If the changes happen, the plan will need to be altered. Yeah, so with drywall, I'm not sure. I think if Dendi is here, maybe he can assist with the drywall part. But other than that, normal plans, if the walls have to change, you will need to get that approval done.
Yeah, because sometimes a wall is there for a reason. It's sometimes a carrier wall to carry a weight. So you cannot just go and break down a wall as you wish or think you can do it. There's sometimes a reason for the wall to be there. And that is why you will have to get an architect and look at the plans, and you cannot just do it. But Dandy, can you hear us? Can you help us with the drywalling, please?
I don't think he's here, so let's continue.
All right. Is there any more questions or something that you would like to add on? Okay, it's now 25 to. Marketed property is quite a lengthy one as well, so I'm going to try to see how far we can come with this one. Okay, the marketed property, the marketing mix in real estate content is essentially a method to communicate to existing and potential clients. According to marketing communications as edited by Kukumur, this communication consists of the following elements. It's advertising, personal selling, promotions, public relations, sponsorship, direct response marketing, technology. And yeah, the one is following actually right into the other one, if you can say that way. And like Moses also mentioned the other day, the 5 or 6 or 7 P's, you know, P's are just carry on and everything. So in this as well. In your groups and with your partner, describe various methods and tools in which you would market a property using the following elements. Let's just take a try on this, I think. There's not really a right or a wrong question. Let's see what we can do. If you do standard advertising, who's going to take a try on, say, what method are you going to use and what tools are you going to use? Can somebody come in?
Rina?
Yes.
I'm just going to mention one way of that we're using for advertising. We've got our local radio here. And what we do is on every day we've got advertisements that go out on the radio station, and then every Friday morning on their breakfast show, they take 3 or 4 of our properties. We send them the links to that, and then they will on their breakfast show put all 4 of these properties out on the air and give a wider explanation of what they are about, where they're situated, the size of the property, whether it's a farm or whatever. So that's we're using radio as one of our advertising tools. Yeah.
That's actually a very clever and a good thing. I wonder why the other radio stations in our areas are not doing the same. Are you paying a lot for that too?
No, I think it's actually quite cheap. We pay 2,500 Rand a month for it, but they run our ads 4 times daily. And then, like I say, we get that on Fridays where we send them the links to the properties on a Thursday afternoon. And then they will take each one of those 4 properties and elaborate on that. You know, as it is on our website, they will go through that whole advertisement there on the air.
That's fantastic. I think that is a very, and especially I think nowadays people intend to listen more to radio, and they don't read that much. So I think your newspaper ads are really not working anymore. In some cases, I think it will still be due, but I think this radio ad is very good. Any comment on this or add on? And personal selling, is somebody going to take that one on? We are actually giving you the answers now. So let's try it, work through it. Personal selling. Who can take this one on? One of our
There's a hand from Vanesha.
Vanesha?
I'm thinking canvassing and door knocking, word of mouth, you know.
Yes, word of mouth, it's a good one. Canvassing also, maybe you've sold a property to a client and then the seller wants to move to another property and you can take him there. So it's without canvassing. You've got him as a client and it's personal selling. Yes. Promotions. This is an interesting, nice one. Who can add something on promotions?
Hi, Rena.
Hello.
Yes, I think doing house shows, specifically, you know, on weekends whereby people are actually not grappling with work activities, I think is one of the promotions.
Yes, 100% correct. Or you can say, put ads out, like for in case, either to the buyers, you can say to them, okay, you will include a dishwasher or a microwave if they purchase this. We like to do that on the off plan for flats sometimes. To get the buyers to buy. And for sellers, you can say, okay, I'll give you 10,000 Rand when I sell your property, or you sign the mandate in selling the property, and when they move, you can give them 10,000 Rand as like a rebate, but they can use it then how they wish. So for you, you can write it off as part of advertising, and they don't add it onto their taxes. Public relations. Can somebody try this one? This is actually also, yes.
No, all I wanted to say is that, you know, this has something to do with your communication skills, you know, how you communicate with your clients, you know. Sometimes when I actually, you know, talk with my clients, you know, I do go to that extent of, you know, asking about, you know, their health, how their kids are doing. I mean, something along those lines.
It's very good, and especially now with the POPI Act. We are not allowed to send out any more bulk emails or SMSs. But if a client gives you permission to keep contact with him, you know, the best way of contact, as you say now, when you get this client, ask when is their birthdays. How many kids do you have? What's their name? What is their birthdays? So you keep like a history, a family history of them. And on birthdays, just wish them happy birthday. You know, how fantastic is it if an estate agent can remember it's your birthday and wish you happy birthday? For sure, you're going to remember that estate agent. And it's not marketing. That is very, very important. It's not marketing. We are not allowed to send out SMSs via marketing, but nobody say that I cannot wish you a happy birthday. And so we have to start playing tricks like this, and exactly what you say. And also what I did the other day is I took my car in for the exhaust to be fixed. And the guy wants to overcharge me. And I said, listen, it's your turn now to overcharge me. Tomorrow, I'm going to overcharge you. So he said, I will never overcharge him. I said, you want to bet? And he said, yes, he'll bet me. I said, okay. His daughter was there. I said, okay, what type of house are you looking for now? And he forgot immediately. He bet me on I'm going to overcharge him. So he said, no, I'm looking for a property in the Montana area, and I would like to have this and this. I said, it's fine. I can get one for you for about 2.5 million. And he stopped thinking, and I said, I'm going to overcharge you. You're going to overcharge me? I'm going to overcharge you. So that is public relations as well. Talk to people. Wherever you come, don't ever be shy that you're an estate agent. Talk to people. Sponsorships.
I'm going to get in here again.
Yes.
We've chosen a couple of institutions that we'd like to sponsor, and one of them is the cancer group, where we sponsor their rallies that they have, or they maybe races that they hold, and then on those we'll sponsor maybe a water point or something like that. And at the same time, we get our advertising out there as well and helping a worthy cause in the case as well.
Yes, that's fantastic. Now that's very nice too. Yes, it's to get your visibility there, and I think that's very, very important. Golf days, there's different type of sponsorships, but the cancer is a very important one. Yes, thanks. Direct response.
Rina,
Yes, Moza.
there was a hand from Weber.
Sorry, yes, I
Yanis.
can't see. Yes, I can't see hands. Thank you, Moses.
Irina.
Yes.
Irina, this is Janis. I also
Yes,
want to say, public relations, like Jaco said, isn't it, for example, we with Remax, and it is also like Remax is doing, is helping us with publicity from their side nationally, and they are basically promoting Remax as a whole, and thereby we are also getting the benefit of that because of the good public relations they are putting out to people.
Yes, 100%. You are 100% correct. Yeah, thank you. Any more onto this? Direct response. That's when you put an ad on your website and somebody make an inquiry and you respond to that inquiry. That's your direct response. Technology, I think here we are going to give a hiding one of these days, but as I said, keeping birthdays and things like that to keep in contact with your clients will definitely be very important. We will have to come up with other strategies. That's luckily our estate agent, I think, is the most inventive group of people, because we always think of something new. So if one door closes, definitely another one is going to open. But can somebody try what we can put under technology for now?
Rina?
Yeah.
If I can try it, Janis, if I can try, maybe it's virtual tours through houses. That we put on YouTube, or we put it on Facebook, where we can, especially with lockdown, the people did a lot of those virtual tours, and in the prospective buyers can see what it looks like. Obviously, you can't see perfectly, but at least they've got an idea of what it looks like inside.
Yes, that's 100% correct. And also, as you say, during lockdown, and what it shows me, this virtual tours, is that if you have a client, you can actually send 3 or 4 virtual properties to the client and say, okay, give me 1 or 2 that you would like to go and view. And I do get the feeling that the sales are much easier then. You don't have to physically go to each property. Because sometimes the women like a specific kitchen. So with a virtual tour, they can see if that kitchen is in their favor or not. And you can easily make sure that you are actually driving less and just taking them to 1 or 2 properties. Anything that somebody would like to add on here? An integrated approach to market would be advisable to estate agencies, thus integrating all the above aspects to a degree. In this way, the organization can derive the maximum benefit out of its expenditure relating to marketing. The most effective blend of these activities needs to be found by each organization depending on their unique business plan and strategy. One agency may find it in its best interest to spend the majority of its allocated budget on advertising and a lesser amount on public relations. It is then found that the public relations exercise resulted in extremely favorable publicity for the agency due to positive feedback received from clients. This positive publicity then leads to the advertising campaign being received very well, as it has provided credibility to the advertising. The objective is to produce a mix that provides the ultimate synergy to market as a whole and results in the best possible returns, both financially and exposure-wise, for the estate agency. your facility. Okay, you are already in the groups, and in the class discuss the following advantages and disadvantages of doing marketing on the internet. In which scenario will an estate agent make use of public relations as a marketing tool? What are some of the promotions an estate agent can offer to prospective clients? Okay, this 2.1 is a bit a lengthy one. Let's see if we can, I think we can do it, or do you want to close for tonight? Moses, what is your suggestion?
I think we can close for tonight.
Yeah, because
so that we don't mix things up a lot.
Yeah, because this one is lengthy one, and I'm just scared I have to rush it off, or we're going to stop in the middle. Is that fine then if we close here for tonight, and then tomorrow night I'm not going to carry on here, I'm going to do the fires, and then on Thursday it will be netback. Would that be fine?
Yeah, sure.
Okay. Okay, any questions up to here? Let's do a question session first. No questions? Going once? Shall we auction the questions? Going twice? No questions, then we must close down. Okay, thank you everybody, and I hope I'll see everybody here tomorrow night. And fires is really very, very important and also interesting in a way. And I really would like to have everybody here so that we can gather some questions for the big guys for Thursday, so that it's worth their while to be here. Thank you, and have a blessed evening for everyone. Bye-bye.
Bye-bye, Rina. Thank you.
Thank you.
Thank you.
Thanks,
Bye.
everybody.
Bye-bye.